all the professional lawyers, academicians, and the students to this webinar, which is on career prospects in criminal litigation, with a special reference to white collar crimes. Friends, this particular topic is of great relevance today because the area of criminal law has always been fascinating, and the prospect of criminal litigation has always been there. And to understand this, we have with us an eminent advocate and scholar, Mr. Vikas Pahwa, senior advocate. To speak about Mr. Pahwa, it needs no introduction because Mr. Pahwa has appeared as a lawyer in so many cases. Mr. Pahwa is a third generation lawyer, and he has been practicing in the Supreme Court and the Delhi High Court. He was designated as a senior advocate in 2011. He primarily deals in criminal law litigation. He handles cases in criminal law like anti-corruption, prevention of money laundering, narcotic drugs and psychotic substances, foreign exchange violations, serious fraud investigations, Official Secrets Act, customs economic offenses, etc. Friends, all these white collar crimes and economic offenses are of much relevance today. To say more about Mr. Pahwa, he was appointed as additional standing counsel criminal in Delhi High Court to represent the Delhi police. In January 2009, he was also appointed as a standing counsel for Central Bureau of Investigation in the Delhi High Court. He has also successfully prosecuted several landmark cases. To name a few, you must have heard about the Maruti Suzuki Indian Limited Manesar factory riot case, in which the general manager HR of the company was burned alive with 90 others. So it was a long trial. He also appeared pro bono for Association for the Victim of Upahar tragedy, in which 59 people died due to fire in cinema hall in 1997. Mr. Pahwa also appeared in the case of Meerut fire tragedy, in which again 64 people died. He is also representing Dr. Shashi Tharoor in the criminal trial pending in the court of a special judge. In 2015, he conducted a felony trial along with the local Greek lawyers. So Mr. Pahwa is also appearing at an international level in different trial cases. Mr. Pahwa has appeared before the court of Dubai International Financial Center, headed by Justice David Steele in Dubai, to defend a client of Indian origin. He is also impaneled by the Delhi State Legal Authority as a senior counsel for appearing in legal aid cases by the Delhi High Court. He is also a criminal lawyer. He is also an advanced course on international criminal law in the Hague Academy of International Law at Hague in November 2018. So these are certain contributions which Mr. Pahwa has made to the legal field. And with respect to this particular topic, I cannot find a better person than Mr. Pahwa himself to speak about a career which he himself has in criminal litigation, and to speak about white collar crimes and economic offenses, so that the students are motivated by his words, and not just students of the National Law University Ranchi, but the students across the country can benefit from his words. I welcome Mr. Pahwa on behalf of National Law University Ranchi. Over to Mr. Pahwa, sir.
Thank you, Mr. Anubhav Kumar, for a long introduction. I think now we don't have any secrets nowadays. We are all in public, domain, and all our information is available online. So anyway, thank you so much for such a long and nice introduction. Thank you, National University of Study and Research in Law, Ranchi, for giving me the opportunity to speak on something which is very unique. In the last about 45 to 60 days, we've been talking about various, subjects, various criminal law propositions which we discussed. But this is something which probably is of great interest to the young students and the young lawyers, because I know we all can correlate with this feeling that when we start our career, we are very skeptical of what our future would be and what kind of law we will practice, whether we will have our own chamber or not, whether we will have clients or not, whether courts will appreciate us, blah blah blah. There are so many apprehensions a young lawyer has in his mind, and one of a very significant question is what field of law he should go in. And we know that in the last about 25, 30 years, we have seen that there are not many people who practice on the criminal side, but there is an influx which has happened in the last about 15 years. When I joined in 1993, I joined my father because he was a criminal lawyer. He still practices, but he doesn't go to the court very often. But since he was a top criminal lawyer, I had an option. So I had absolutely no predicament whether I should opt for criminal litigation or a civil litigation. I had no inclination for civil at all, although I was pursuing my chartered accountancy. But since I have seen my father from childhood practicing criminal law, so I had a little bit of idea. So therefore, there was a natural inclination to join criminal law. But before a student or a young lawyer takes a plunge and joins the criminal litigation, he should have a general idea about what criminal litigation is all about. Because in my view, criminal litigation is very different than civil litigation. Criminal litigation is very wide. If we talk about a normal civil law case, when there is a dispute between partners or shareholders or two neighbors or two brothers, they go to a lawyer, tells him what the facts of the case are, and gives him the documents. The lawyer prepares a plaint, a suit which he files in the court, goes to the court, argue, takes the order, give the copy of the order to the client. So civil lawyers primarily are busy in the court proceedings. But criminal lawyers are lawyers who go beyond the court proceedings because they have to uh, participate in the entire criminal justice system. Now, criminal justice system has at least four wings, according to me. So you have, as a criminal lawyer, you have to deal with all the wings. You can't say that I will only argue the matter in the court. I will not advise the client on pre-litigation or pre-trial proceedings. So the four different wings which a criminal lawyer should know are: first is the police, that they have to deal with the police. Criminal lawyers also have to deal with the prosecution department. Criminal lawyer have to deal with the judicial aspect of the matter, and also the fourth is the prison, the jail authorities. Now, a criminal lawyer has to deal with all four. So that is why criminal lawyer is a very niche field where I, in fact, consider authentic criminal lawyers are lawyers who do only criminal law work, because you can't do civil and criminal both. Of course, there are many lawyers who are doing both. But in my understanding, since it is a very complex and very distinct field, so only those lawyers who primarily deal in criminal law and who are a bit successful in criminal law, you find that they would not do anything else. I've never seen my father or my grandfather doing any civil case in their life. Similarly, although I started off doing many civil cases, I continued to do them uh, sometime, but the percentage is very, very less. So therefore, a criminal lawyer has to be part of the criminal justice system. So he will go to the police. He will, help the client to represent him or her before the police. I'll explain it to you that in a bit. But let me just explain it to you what kind of lawyers are there who practice on the criminal side. So there are 6 or 7 categories who are practicing on the criminal side. Number one are the prosecutors. So there are lawyers who love doing prosecution work. They have a niche in the prosecution department. So for many years, I've seen people, those who enjoy doing prosecution, continue to do that in that department. So prosecution, uh, public prosecutors, you have standing counsels, you have district government counsels, you have additional solicitor generals. These are the people who represent the investigating agencies. Then we have defense counsels. So defense counsels are counsels who represent the accused in the court. Then we have a segment of lawyers who appear for victims. So third category is the lawyers who represent the victims. Fourth category is lawyers who are employed by a law firm, but have a good understanding of criminal law, because a lot of corporates, big corporates, want consultancy on the criminal side from the law firm. So even law firms employ certain category, certain group of people, those who specialize on the criminal side. So you have an option of joining those law firms. Then you have an option of going to legal aid. Now, legal aid is kind of a service which is very important, and one I always recommend that it's important for every lawyer to become part of legal aid for at least 2 to 3 years. So fifth category is the legal aid counsels who interact with the accused, those who are in jail, who can't file their own case, who don't afford a big lawyer. So they interact. And nowadays, I've seen many lawyers of substantial standing at the bar are appearing on behalf of the legal aid. And then sixth category is a category of lawyers who join a corporate. These big multinational companies nowadays prefer lawyers who have knowledge on the criminal side, because the offenses are on a rise. So you have 6 7 categories of places where you can work. So I've explained to you 6 of them. So before you decide, before you take the plunge, you must have a feel of what this practice is all about. It's always better to understand where you are getting into. So I think the students today probably have an advantage because they can do internships with the lawyers to understand what criminal law is all about. And I have seen the number of requests which we are getting nowadays. In my chamber, I can at least say, has grown exponentially in the last about 5 to 7 years. So we have a lot of requests from students who would like to intern on the criminal side, which shows that now students have interest to work on the criminal side. So what is the basic difference between a civil and a criminal lawyer? So as I said in the beginning, a civil lawyer primarily goes to the court, files the plaint, argues the matter, gets a relief, and gives it to his client. So his major time is spent in the court proceedings. Now, if we see a criminal lawyer requirement starts the moment crime is committed. If the crime is committed, then you will find the affected party or the accused contacting the lawyer at a very initial stage to understand what are the repercussions of those crime. In case a victim contacts a lawyer, then the lawyer's job is to help him in drafting the FIR, to make him understand the consequences of that act and how he should proceed further, how an FIR has to be registered. So you see the involvement of a criminal lawyer is much wider than the civil lawyer, because he has to deal with the other departments also. So his expertise is required at the stage of preparation of the FIR. His expertise is required when the investigation is going on, particularly if, since we are focusing more on the white collar crimes normally involve a lot of documents and interpretation of documents, and a lot of forensic science knowledge. So therefore the criminal lawyers demand and his involvement starts at a very nascent stage of the case. So investigation is a stage where a criminal lawyer has to assist the party, whether he's a complainant or an accused. And very often we see that if the client engages a lawyer at a very initial stage, then the case is much better fought. So sometimes we know how the police tries to extract confessions from the accused, how they extract information from the accused. So therefore the advice of the lawyer at that point of time becomes very important. A good strategy by a lawyer given to a client at the stage of investigation helps the client to fight the case in the court. So therefore, his involvement starts very early in investigation. He goes and assists uh, the client, and then when the matter is about to start, when the investigation is concluded, then of course his involvement in the trial court also starts. And before that, when the bail applications are filed by the accused. If you are for a complainant, you oppose the bail. If you are for the accused, then you seek bail. So the involvement starts very, very early. And then the trial, how the documents have to be procured, that itself is an art. So a criminal lawyer, I'll just tell you what are the good qualities of a criminal lawyer. But let me explain it to you the procedure first. So, FIR, investigation, pre-trial inquiry, then how the trial starts, how the defense is created, how the cross-examination of the witnesses is done, and then finally, when the argument is made, written and oral argument in the court, then also his involvement is there, and finally the judgment, and then the appeal. So you see the distinction between a civil lawyer and a criminal lawyer. The scope of work of a criminal lawyer is very, 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 very wide. So his involvement is at various stages of criminal justice system and the various stages of the inquiry and the trial. So before you decide whether you have to take civil law or criminal law, one must see that as a criminal lawyer, there's a lot of hard work. There's a lot of you have to burn your midnight oil in preparation of cases, and there are various other traits and qualities which are required, which I'll explain it to you. So I've told you in nutshell what all criminal lawyer has to do. Now, criminal law, as you know, has suddenly got glamorized. The glamour has come in the last about maybe 10 years. And as far as my understanding is that the influx of young students who are opting for criminal law started somewhere in 2000, because 95, 96, when the RBI Act was amended and SEBI Act was amended, which resulted into collapsing of various big companies in the country, and that resulted into multiple litigation in various forums, including the criminal litigation. Then lot of work came into the courts, and thus more and more lawyers started coming and doing the criminal law. And recently, I've seen, this Netflix. There are some serials in the Netflix which has also attracted a lot of students. I would say Boston Legal was one. Anybody who has seen as a student, feels that yes, this is a very exciting field, and we must opt for criminal litigation. Then we have Practice, and then we have The Good Wife, and then we have Suits. Suits, again, a serial in Netflix which has attracted a lot of viewership, and people, those who are not even into criminal litigation, get attracted. So these serials also have created an impact on the mind of the people that yes, they can opt for criminal litigation, because the initial apprehension of every student is as if it is a dirty job, as if it is a dangerous job, and some people feel that only those people can opt for criminal law, those who are there for generations. I myself don't agree with that. I have seen youngsters, first generation lawyers, doing very well in criminal law, and without any background, because they have the aptitude of doing it, so they picked up and they are doing really well. Of course, if you have somebody in the family who's a lawyer, there is an advantage, but that advantage is only to start with, not throughout your career. Of course, when you start, if you know someone, you have a relation who's into practice or who's into judiciary, can help you in getting a placement, but will not help you in getting your practice. Your practice comes only on your own personal hard work. So now, if you, I was requested to speak primarily, criminal litigation vis-a-vis white-collar crime. So you must understand what is white-collar crime. White-collar crimes are crimes which are committed by the higher strata of society. People, those who are in a dominating position in the society, if they start violating law, particularly if it is linked with economic offense, then it is called a white collar crime. So there is huge work in economic offenses and white collar crime in our country, which can attract a lot of students and young lawyers to come and join criminal law practice. So we have special statutes which deal with these offenses. We have a money laundering prevention of money laundering act. We have NDPS act. We have prevention of corruption act. We have companies act where the new chapter has been introduced, which is giving rise to a lot of work for criminal lawyers. And we have Food Adulteration Act. I mean, just name it. There are hundreds of acts which are giving rise to cases all over the country. So these are the offenses which are normally tried in the court. Of course, it takes time. New lawyer obviously will not get the work immediately. You have to join. I've been telling everyone in these webinars that in criminal law you can't take the plunge on your own. You have to join a chamber. You have to join a senior who can teach you how to conduct cases, a senior who can teach you what the principles of law are, who can teach you the nuances of law. So it's important for a criminal lawyer to join someone, start practice in the lower court. So that is one aspect of the matter. And then just to tell you in nutshell, what are the general skills which are required to become a criminal lawyer. So first and the foremost is that you should be a 24/7 lawyer. Unlike a civil lawyer, criminal lawyer works 24 hours, not in the office, but his mind is working 24 hours because anybody can knock onto your door even at night. So when a crime is committed, the aggrieved party can come and contact you at 2 o'clock in the morning or 5 o'clock in the morning. So criminal lawyers work 24/7. I remember when I was very, very young, and my father being the top criminal lawyer of that area, he was invariably once or twice in a week, somebody will ring the bell and would like to come and meet him and request him to draft the FIR or guide them how to deal with this problem. And very often he will wake me up and tell me to take the dictation of the FIR, which he's dictating. So one should be ready to work 24/7. And that can only happen if you have a passion. Nobody can force you to become a criminal lawyer. You can only become a criminal lawyer if you really want to be, if you have the passion for that field. So this is one, because it has long working hours. Even when the matter has not gone to the court, still you are consulted. You have to do a lot during that period. So it's a continuing process. And when you become busy, when you have more number of cases, then the working hours certainly increase. But it all depends on an individual. You can always modulate your schedule and keep the working hours which are convenient to you. So I'm talking about early years. Of course, at our stage, we do modulate, we do streamline the system and make sure that we work only to those limited number of hours if we want to. Now, second important quality of a criminal lawyer is to absorb the facts in the right perspective. Criminal law primarily revolves around facts. So it's important that one should have an analytical mind to understand the facts in the right perspective. So that quality, of course, you improvise, you gain after working for many years. But it is important for a lawyer to see whether he can absorb the facts or not, or whether he can, if he prepare a chronology of facts and then you read those facts, can you absorb those facts in the right perspective and also have a sense of imagination to see how this crime must have happened? If a set of facts is given to a criminal lawyer, and criminal lawyer has to apply his mind, and he also has to visualize and imagine in his mind how the crime must have happened, so that the sequence of events which are given to you gets clarified. And then the problem solving skills. A criminal lawyer is also required to have a problem solving skills, that when a problem is given to you, you have to find a solution. Very often, when the clients come to us, they expect that we will give them a solution. A lawyer who cannot give a solution to the client cannot be a good lawyer. You have to come up with a solution every time a client approaches you. So one should have that knack of understanding the facts and the law and telling a solution to the client. The client is always very happy. So you can't be 100% correct every time. But yes, what is expected from you is that you have to give solutions. Fourth quality is to read documents. Because unlike in the civil law, because civil law, as I told you, is primarily a plain documents. But in criminal law, what is important are the investigation documents. So one has to understand, apart from law, one has to understand how the crime has taken place, how the investigation has been conducted in the case. So one should know how to read those investigation documents. In every state, they are in regional languages. So one should understand wherever you are practicing, you should be able to read that vernacular language, the local language, so that you understand those documents. Understanding of reading on understanding of those documents is very, very important. And one of the other qualities, enjoying the challenge. You must enjoy the challenge, because taking relief in criminal law is not easy because the system is against you. There are various prejudices which are in the mind of the investigating agency and sometimes even the judiciary. So you have to deal with those prejudices, trying to dispel those prejudices. So you must enjoy taking that challenge. And a lawyer who enjoys taking that challenge ultimately wins the case, because you don't get relief in a jiffy. You don't get relief at the first instance. Sometimes you have to fight it out. A good criminal lawyer should understand the forensic science. He should understand the cyber law aspect of it, because when we talk about white collar crime, when we talk about the crimes which happen through the information technology, so these are composite knowledge, and then the presence of mind, and you have to be a good communicator, you have to be a good orator, you should write well, you should be able to speak well. So these are all multiple qualities of a lawyer. It's not necessary that to be successful, you should have all these qualities. Even if you have 60%, 70% of these qualities, a lawyer can pick up criminal law and start practicing. Because with passage of time, you learn. So you can't expect to have these qualities right in the beginning of your career. But if you start with a good lawyer, you will see how you imbibe those good qualities which your senior has. So you will learn from him. So there are many things which you learn in the process, so which you can't learn right in the beginning. And then, since the topic is career prospects, so I have to also speak about the prospects. And I personally feel that the criminal law work has increased a lot in the last about 20 years. The number of lawyers have also grown in the last 20 years. I When I came to Delhi in 1995, of course, that's the time when the change was happening, when the economic offenses wings were created all over the state. The Delhi Police Economic Offences Wing suddenly got a lot of cases in 95, 96, 97 when I came. So we had the opportunity to get involved in those cases. So according to me, there are huge prospects in criminal litigation. One should opt for it. If you think you have the aptitude to become a criminal lawyer, you have the capacity to work, say around 17 to 18 hours a day in the beginning, and you also are ready to take the plunge, because as I had explained, there are various wings of criminal justice system which you have to deal with. One should be ready to deal with them. A criminal lawyer may be required to go to jail to meet the client, to represent, and to gather information from him. So all these aspects have to be taken into consideration, because there are some lawyers who would prefer to sit in an air-conditioned room and do the work. Uh, Criminal lawyers sit in the air-conditioned room only in the evening after finishing their work, when they have to do conferences and maybe start drafting. Most of the time, they are on a run from one court to the other. It's a hard work. It's a real hard work which is required. So just to give you a general idea of what kind of white collar crimes and criminal cases we are talking about, we are actually talking about cases of Prevention of Corruption Act, where a lot of traps which happen, the traps which are conducted by CBI against bureaucrats, against police officials, and the senior level officers in a corporate. And we have cases of criminal misconduct under Prevention of Corruption Act. We have cases of money laundering which are being registered now rampantly, across the board. And then we have a case under the Companies Act, which was amended in 2013. And we have cases of NDPS Act, Narcotic Drugs and Psychotropic Substances Act. We have many fields in which these kind of cases are filed. And we all remember there's a 2G scam case. We all know coal scam cases. We all know a Commonwealth game scam case which happened. There are bank frauds. There are people who have taken loans from banks and they're not paying. People, those who have forged collateral securities and taken loan from the bank, they are being prosecuted. So you can be a prosecutor and prosecute them. You can be a lawyer for the victims, because in these real estate frauds, there are millions of people who are affected. They all want justice. They all want to prosecute the real estate owner, the developers. So you can always represent those people, those who require your services, because victims definition has recently been broadened, been widened up in 2009. So a lot of people who are victims of the crime, they can now come to the court. Their rights have been more clarified, and there's an amendment in CRPC giving them the option to prosecute. So there are many cases, right? And you must understand, in criminal litigation, the primary litigant is the state. Most of the offenses, heinous offenses, are prosecuted by the state. That is why the prosecutors become very, very important. So I give very, too much of respect to the prosecutors, because prosecutors do a lot of sacrifice, and they don't look for the lucrative practice, and they dedicate their life in prosecuting people. So we have to salute them. But I always feel that prosecution department also should have a process of circulation, because there are people who are prosecuting for 20 years, but if they employ good lawyers for 5 years, 6 years, and then allow them to retire and then join their private practice, probably we will see much more better lawyers opting for prosecution. So since state is the primary investigating agency, then we have prosecutors who prosecute the accused persons. Now, I would like to touch the most important part of my talk today. The most important part of my talk is the rules of professional standards. If you are opting for criminal practice, then it is very important for you to understand what are the rules of the professional standard. Although the rules, you will not find them in the Advocates Act, but Bar Council of India has framed certain rules. And I'm not saying those rules are only for criminal lawyers, but I must say that they are more important for a criminal lawyer, because criminal lawyer is doing work at various fields, like dealing with the police, dealing with the prisons, dealing with prosecution department. I feel for them it's very important to understand what are the rules of professional standards. So I would like to discuss with you the rules of professional standard for a defense counsel, and then rules of professional standards for the prosecutors. They both are different because their roles are entirely different. So therefore, it's important for me to discuss these rules with you. Before you take a plunge, it is important that you understand what are these professional standards are. Why I'm saying is important for a criminal lawyer, not as important for a civil lawyer, is because in criminal law, most of the time, you are representing a client who's not with you. You are representing someone who may be either in jail or who may be not available with you because you are trying to get relief for him because he's wanted in a criminal case, or there is a perrocar or a power of attorney who comes to you. So the client is not in front of you. When the client is not in front of you, then you may have to get involved in many things on his behalf. So once you are entering into those transactions on his behalf, then you have to be very careful of what you're doing and the kind of services you are providing. That is why I'm saying for a criminal lawyer, these professional standards, rules of professional standards are very important. Now, let me explain it to you. What are those rules of professional standard? The first and the most important is that your communication with the client is a privileged communication in terms of section 126 of the Evidence Act. Sometimes, as a defense counsel, the client comes and confesses and shares certain information with you, which is privileged, which he has shared with you because you are his lawyer. So you must understand that you can't share that information with a third party. You can't even share those information with your family members. You can only share that information with probably the lawyer who's assisting you, the office staff who's there with you. Otherwise, you have to respect the privilege which has been assigned to this communication. First. Second is you are representing a party, and this party is having a litigation with the opposition party. So your communication with the opposition party becomes very, very important. So you have to be very careful when you are dealing with that information, that you don't have to interact with the opposite party and share those information with the opposite party. And once you have been advised or consulted, or your advice has been taken by one party, you can't appear for the other party. Although this rule will apply both for civil and criminal lawyer, but because there are multiplicity of areas in which you advise your client. So suppose somebody has taken advice from you during the investigation part, but has not engaged you for the court. So you can't appear for the opposition party when the matter comes to the court. So that is what I'm saying, that once somebody engages you, even takes an opinion from you, you can't appear for the opposite party. And then you can't uh, work on success fee. It is not permitted in our country. You have to charge your fee. You can't charge success fee from the client. You can't purchase the property which is procured or purchased from the money involved in the litigation. You can't do that. You can't be a surety of the client. For a criminal lawyer, if suppose your client has been granted bail and he doesn't have a surety, you can't stand surety. The rule says, sorry, you can't do it. You're a lawyer, you are a professional, you have paid for him, granted a bail. Now let him arrange for a surety. If you are a witness in any crime, you can't appear in that case. If you are involved, if you have an interest in a body corporate and body corporate is involved in litigation, you can't appear in that matter. You have to uphold the interest of the client whenever you appear for him or you do his work. And you can't instigate the litigation. It's very, very important. Sometimes multiple litigations start. You can't instigate that. You can't, file cases just for the heck of it. You have to file case only if it is in the interest of the client. And then you can't appear without the wakalatnama. Suppose there is a lawyer who's already there, who's already appearing. You can't appear unless and until you take a clearance from the lawyer who is already advised. And then the most important is you are bound to appear for every client. You can't say no to a client just because he has committed a heinous crime. Of course, there are certain exceptional cases in which you can say that you can't appear, but normally you can't say no to a client. That, according to me, will amount to professional misconduct just because you feel like not appearing for him. So these are few of the professional. These are some of the professional standards which are given by the Bar Council of India, which one should keep in mind before you take up criminal litigation. Now, when we talk about the prosecution department, talk about public prosecutors, when you talk about standing counsels, my personal feeling is that there are certain rules again for them, that prosecution, if you opt to become a prosecutor, what should be your duty? Your duty should be to be independent in the court. Very often the prosecutors start realizing that start feeling that they are actually lawyer for the investigating agency. They are not. They are lawyers for the state, and state's job is not to convict a person who's not required to be convicted. So therefore the prosecutor's job is to be independent. Prosecutor's job is to assist the court in arriving at the truth. Prosecutor's job is not to suppress the material from the court, because sometimes what happens is, suppose we have 100% material, out of which 30% is in favor of the accused. The law requires that entire 100% should be given to the court, and let the court decide what material the court finds is relevant enough to be relied upon so that it can be used in the court. So the ultimate duty is of the court to analyze the evidence. So this is a big controversy. In fact, where certain prosecutors feel that no, their job is to get conviction. In my view, it's not their job to get conviction. Their job is to get justice for the parties, whether it may be victim or it's an accused. So I remember one incident when I was a standing counsel in 2010, probably. In fact, nine, when I just joined in 2008, somewhere in the end 2009, I was young, and I there was a case which came up before the High Court, and I when the lawyer for the petitioner completed his argument, I got up and said, "Yes, my lord, what my friend is saying is absolutely right. This order, which is passed by the trial court, is a completely illegal order." So the honorable judge asked me, "Mr. Pahwa, are you conceding?" I said, "I don't know, my lord, whether it's concession or what. I'm just telling you what the law is. This order is absolutely illegal." So the honorable judge recorded my observation and allowed the petition. And after about week or 2 weeks time, I was contacted by the officer of Delhi Police, maybe CBI, I don't remember, who said that, "Mr. Pahwa, where there's a matter where you had conceded. The department has challenged it in the Supreme Court. SLP has been filed listed before the Honorable Chief Justice of India, and the additional Solicitor General is appearing in that matter." I felt a bit odd. I thought maybe I have done something wrong. So the SLP is listed. Matter is argued by the ASG, and the Honorable Chief Justice of India is reluctant to issue notice. Says that your standing counsel has conceded, and but the ASG said no, it's an absolutely illegal order, and somehow he argued at length, and the notice was issued. On the next date, when when the matter came up for arguments, the Honorable Chief Justice said, "Sorry, I issued notice only because you were insisting. Now I would like to dismiss with the cost of 1 lakh of rupees." And the ASG had to really work hard to accept only the dismissal, and requested the Honorable Chief Justice that please don't, issue any cost, impose any cost. Let it be dismissed. And somehow the cost was waived, and the matter was, the SLP was dismissed. And I was informed that your, concession has been accepted by the Honorable Supreme Court also. So then I got that confidence that as a prosecutor, my job is to assist the court. My job is to do what is appropriate, what is legal. So, for a standing counsel, for a prosecutor, his job is not to secure conviction, even when the man is innocent. There are various judgments which have been passed where the duties of a prosecutor has been defined and discussed by the Supreme Court. I would like to share few citations with you. I really enjoyed reading the judgment of Shiv Kumar versus Hukum Chand. This is 1997, volume 7, SCC 467. Then I remember a case of Manu Sharma, that Jessica Lal murder case where Mr. Jethmalani uh, argued on doctrine of disclosure. What is the duty of the public prosecutor to disclose documents to the court? Whether he can hide, whether he can conceal, or whether he can withhold documents and don't file it in the court. It's a very beautiful discussion with regard to his argument, and ultimately the court upheld that yes, it is the duty of a prosecutor to file everything before the court, and he can't withhold the information. So Manu Sharma's judgment is reported in 2010, volume 6, SCC, page 1. And then Manu Sharma's judgment is reiterated in the case of V. K. Sasikala, which is reported in 2012, volume 9, SCC, page 771. So it's an interesting reading. There are many judgments on the professional standards, rules of professional standard for a defense counsel. If you do the research, you will find many of them. But with regard to prosecution, these are the only 2 or 3 judgments which we have. Now, I think one of the apprehension in the mind of all the students and young lawyers would be whether this litigation is lucrative or not, because at the end of the day, we all want to earn money. But let me tell you one thing, that legal profession is basically a service-oriented profession. Please, when you join the profession, your objective should be to serve the people. While serving the people, while excelling in the profession, the money comes automatically. You don't have to work very hard with it. This is a lucrative profession, both civil and criminal side. You can opt for any of the fields, but criminal litigation is lucrative, not in the beginning, maybe in the end. Maybe after 10, 15, 20 years, you start earning more money than the civil lawyers. But it requires a lot of hard work. It has a long gestation period. You have to spend at least 5 years to understand what criminal law is all about. Obviously, your start is not as good as a start in a law firm, because law firm obviously offers you monetarily much more than the criminal law. But criminal law, if you get going in criminal law, if you are into that momentum and you work hard for the first 5 to 7 years, you will see that you may be better off than many other lawyers. I'm not saying other laws are bad. They are equally good. Sometimes they are much better than criminal law. But anybody who's interested in doing criminal law should know that the hard work is much more. The gestation period is long. So therefore, you may have to wait for the right time. But then as far as I'm concerned, my personal experience has shown that I have enjoyed that initial struggle. And because at that point of time, our objective is to learn. Our objective is, to grow into the profession, to do as many cases as we can. So therefore, if you enjoy that initial struggle, you will see it will be a very smooth transition. There'll be absolutely no problem. So I wholeheartedly recommend that you must opt for criminal law. Criminal law has huge, great prospects. Criminal litigation is challenging. Criminal litigation is satisfying. Criminal litigation gives you an opportunity to help people, those who are in trouble. It keeps you connected with the grassroots level. You learn from the mistakes committed by others. You will see how one person who has committed a mistake has landed in jail. So you learn from those mistakes. You also teach your friends and your family around you that don't do this, because you can land in trouble. So we are aware of the negative part of life, which makes us stronger and which makes us more aware of what is happening in the society. So it's a interesting profession. You must opt for it, and you must have patience and wait for the right time and take the plunge. You should not start practicing the moment you join criminal law. You can only start practicing after a few years when you see how the cases are conducted in the court. When you learn how the cases are conducted in the court, only then you should take the plunge. So I can continue, but in case you have questions, I've done almost 50 minutes. So if you have questions, then you can please ask me. Mr. Anubhav, will you be asking me questions? Do you have questions which are coming to you? I can see some live comments. Yeah, I can see Mr. Anubhav. I can't hear you. I think you're muted. You have to unmute yourself first.
Sir, it was very intriguing, sir, indeed,
Yes, yes, yes.
because in class as academicians, when we teach our students, we tell them about the theory part, but the
Yes,
practical and application based thing is told by you. So actually, the laws are tested in the courts, and so that is very
absolutely.
important. Few questions, some of the questions which are coming up are regarding the nowadays, sir, because in the COVID-19 period, the courts are functioning in the online manner in many areas of the country. The courts are working online, so e-court system is coming up very fastly. So, how do you suggest there the role of the lawyers would be very important as a criminal lawyers, like bail applications or for appearances and etc. So, how they should now come deal with this kind of situation?
I think it's very easy. One has to only adopt to the technology. I have appeared in many cases in the last about 60 days. Many of my briefing counsels and young colleagues have filed bail applications in the courts. The bail applications are filed online, they are accepted online. Of course, there was some difficulty in the beginning with regard to getting the wakalatnama from the jail because the accused was in jail. Very difficult to get the document signed because in complete lockdown, you can't go out, but gradually all that has been sorted out. And I have been advocating throughout that, according to my understanding, it's not appropriate to open the physical courts now. We should use the technology. We should use e-courts. We should use the cyber courts, as they say now, for the purposes of arguing these bail applications. So what is being taken up in the court nowadays are cases which affect the liberty of an individual. And fortunately for us, although the crime rate has really gone down, there are no arrests which are happening, only those arrests where some very serious crimes have taken place. The investigations have stalled for the time being. So, therefore, we in any case can't do much in the investigations. But filing of bail application online, arguing online is very smooth, very comfortable. There is absolutely no problem. The orders, the bail application are accepted and long are, and I myself have experienced. We have argued bail application for 2 hours, 2.5 hours before the Honorable High Court. Last week we did 2.5 hours, and the Honorable Judge gave us that liberty. So there was absolutely no problem. Opposition from the other side, we argued. The other counsel also argued. The order is passed, it's dictated, and by evening we got the order. We supplied the order to the jail authorities, and the man is released. In case we have to file sureties, we take the order, take the sureties to the court, and it's happening very smoothly. So I would like to encourage my fellow lawyers to adopt to technology and start arguing matters by video conferencing.
Sir. And sir, as you have mentioned that there are different kinds of white collar crimes being committed in the recent past, and in this COVID-19 situation, most of the transactions are taking place online. Earlier, also it used to take place after demonetization, but now they are quite frequent. And as you mentioned about Netflix and other online shows. So there was one very famous show, Jamtara. Jamtara is a district in Jharkhand, and it
Okay,
is
okay.
notorious or well known for the cyber crimes which has been committed in the country. And in
Hmm.
fact, it is the cyber crime capital of the country. Now,
Okay.
I would like to know how what can be the prospect of the budding lawyers in a cyber crime area, particularly as a criminal, as a part of criminal litigation. What are the prospects in that?
I think the prospects are very high, and Information Technology Act is a very comprehensive statute. One can easily pick up cases in that, and we every district we have a cyber cell. Every economic offences wing has a cyber cell, and there are people who are specializing in cyber law cases. There are various frauds which have started taking place. People enter into your bank accounts, and they withdraw the money. It's happening every day. So there are lawyers who specialize only on that. There are people who have written books on cyber law. So it's a great field, provided you understand the implication how the system works. As I told you, for a criminal lawyer, going to the court is not the only solution. You have to also participate in the investigation. You have to guide the victim how his money has been swindled away, how the account has been hacked. So therefore, you should have a knowledge about that subject. If you have the knowledge about the subject, one can always pick up cyber law as a distinct field for practice.
True, sir. True, indeed, sir. So I think uh, there is another question which is coming up, sir, which is regarding uh, the All India Judicial Service uh, insights about the AIJS bill at the end of the. Okay.
We'll talk about it. Yes, yes.
Oh, sure, 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 sure.
Okay.
At, at a later stage, we can deal with this
Yeah.
topic as well.
Yes.
So I think perhaps there are not much of the questions coming up. So
Hmm.
I think a little more discussion could take place regarding the white collar and economic crimes, because
Okay.
in National University we are also having uh, a specialization in the criminal law. So white collar crimes is also a part of their curriculum as part of a specialization.
Hmm. Hmm. Hmm.
So we are dealing with almost the specific statutes, almost all the specific statutes for the white collar crimes. So if we see the jurisprudence of the white collar crimes, we discussed like in the class, like sir, the what the idea propagated by Sutherland long back in 1940 regarding white collar crimes, that it is a phenomena normally found in the high class people, which is different from
Hmm.
the blue collar crime or the traditional
That's
crimes.
right.
So indeed, the new the new crimes which are coming up also needs the requirement. There is a requirement of the lawyers to be smarter than criminals. So that's what, as you have already emphasized, that you have to be
Yep.
aware of the forensics and everything. But then, sir,
Absolutely.
that part is also I think should be highlighted, that how you can be
Hmm.
smarter than the criminal lawyer can be smarter than the criminals themselves.
I can only say it's not a case of being smarter than the criminals. It's just that how to understand the psychology of a criminal. So, a criminal lawyer, not because he has done any specific course, by doing those number of cases, we after 25 years, we can read 500 pages in 5 minutes. It's because of the experience which we have. So, similarly, by doing those number of cases, we understand the psychology of a criminal, how a criminal functions, why he commits a crime, how he commits a crime, what are the loopholes. So, that comes naturally when you practice in that field for 10, 15, 20 years. So you don't need to be smarter than them, but yes, of course, since you have massive experience, you should know how to appreciate it. Anubhav, on the right hand side, I can see a lot of questions in the live comments.
Definitely, sir.
So if you want, we can pick up those. There is a
Sure.
Simranjeet Kaur Bakshi says, Could you shed some light on the judgment of Delhi High Court on Sajan Kumar versus CBI? Okay, this Sajan Kumar versus CBI case, I think I appeared in that matter when the order on charge was challenged by Mr. Sajan Kumar before the High Court, and the charge was upheld by the Honorable High Court. Again, Mr. Sajan Kumar has gone to the Supreme Court challenging the order, and that order was upheld. That was a case where you can, if you want to read that, you read from the perspective of jurisdiction of courts at the time of framing of charges, that what is the law when the charges have to be framed. What is the test is that in case there is a grave suspicion against the accused, then charges can be framed. So Sajan Kumar case is important for that. And then Manas Sharma says there is a perception that litigation in early years is very ruthless. uh, Manas, I told you that in the beginning, when you start litigation, whether it's civil or criminal, you have to undergo that tough training. It's not easy in the beginning. You can only enjoy that if you start liking it. So that's what I say. You can nobody can force anyone to become a good criminal or a civil lawyer. You can become a good civil or criminal lawyer only when you start liking it, when you start enjoying it. So I don't think it's ruthless at all, but yes, it requires hard work. And then, as per the PCA public servant, this is Piyush Singh. As per the PCA, public servant can be investigated for a white collar offense. However, under Section 17 of the Act, mandates a prior permission for any such investigation. Yet, this is an amendment. PC Act has been amended in 2018, and I in fact recommend all of you to read the amendment, because amendment has some very serious consequences, because the law has been clarified and mollified. The rigors of law has been mollified to a certain extent. And you must understand why Section 17, 17A has been brought in. They have been brought in to protect the frivolous cases which are filed against honest public officials. So Section 13 has been amended, Section 19 has been amended, 17 has been amended, 17A has been brought in. So one must read that, and I recommend all of you to understand the amendment, because amendment is giving rise to multiple litigation all over the country. So therefore, it's an interesting point. But 17 mandates prior permission is that, there was a single directive issue under Delhi Special Police Establishment Act, Section 16A, which was declared unconstitutional in the case of Mr. Subramaniam Swamy. So now in the amendment, after it was declared unconstitutional, 17 has been brought in, where they are saying that before you start investigation, you must take prior permission. In 19, the prior permission is for prosecution, but 17 is even for the investigation. So this is to protect the honest officials. How to develop what is his name? Mr. Prasant Raju says how to develop forensic skills, cross-examination, creativity to connect the dots, and out-of-box thinking, particularly when you know the client has very low chances of success. Okay, I think the most pertinent part of your question is that when you know that client has very low chances of success, uh, Mr. Raju, as a lawyer, we don't apply too much of mind on the final result of the trial in the beginning, because sometimes a defense counsel has to build his case brick by brick. So if you start applying your mind on success and failure, then you will not be able to do justice with the case. So what you need to do as a lawyer is you have to analyze the documentary evidence which is in front of you, find the best possible defense for your client, and move ahead with the trial. Sometimes you see that a point which is the most important point for acquittal in a case arises somewhere in the middle of the trial. Sometimes a mistake committed by a witness can result into acquittal. Sometimes mistake committed by a prosecution results into acquittal. Sometimes non following something mandatory in law result into acquittal. So there are many ways in which acquittal can be achieved. So there is no straitjacket formula. So therefore, you must not apply your mind on the final chances of success. Move ahead with whatever you have in hand. So cross-examination, if you have the documents in hand, please prepare your cross-examination accordingly. Then Mr. Jay Krishnan Sharma says, in the economic crimes or otherwise, getting an FIR is a bit difficult task. Non-registration of an FIR provides various remedies like. You're right. Nowadays, the police is very often reluctant to register the FIR because registration of FIR means increase in the crime rate. And no station house officer wants that the crime rate of his area should increase because it will be reflected in the books. And the commissioner will say, look, your area has the maximum crime rate. So he says the best thing is not to register the FIR. So the solution is simple. Solution is if he doesn't register the FIR, go to a senior police official under section 154(3), go to a magistrate under 156(3), satisfy him that it's a case which requires police investigation, file an affidavit along with 156(3) application in terms of Priyanka Srivastav's case, convince the court, take an order, give it in the hands of the SHO and say, now, my friend, you have to register because the court has directed you to do it. And then Mr. Rishabh Kumar says, what is your say on whether the laws are sufficient to curb the endemic white-collar criminality among lawyers and judges? Well, there's no white-collar crime among lawyers and judges. I don't know why you have asked this question. If you have something else in your mind, I think you might as well ask me direct questions, not indirect questions. If you're talking about corruption in judiciary, of course, I would like to address that. But your I think question is erroneous. White collar crime between lawyer, I don't understand what you're saying. So Mr. Nandita Kukreja says, good evening, sir. My question is in regard to a budding lawyer, how are we supposed to differentiate between what sort of lawyers should we begin with at the district level court? Well, I always advise my interns who come and the lawyers who join is that they must have experience both in civil and criminal. They must join a criminal lawyer and also join a civil lawyer because as a criminal lawyer, you must understand the nuances of civil law also because there is a very delicate distinction between both. So you spend one and a half year with a criminal lawyer, same time with a civil lawyer, and after that you take a call whether you are best suited for a civil lawyer or a criminal lawyer. The best way to understand and learn is go and see in the court, go and work in the court, join a lawyer in the court. Then your inner voice will tell you what is good for you. And then Mr. Divyansh Singh.
Divyansh is an interesting question.
How far is restrictions imposed by Section 3012 CRPC on the private counsel engaged prosecution justified? A very interesting question. I recently argued this in the court at length, so I can answer right now. 3012 is a power which is given to the complainant's counsel to assist the prosecution. Now, complainant counsel has a very limited role. There are various judgments. Some of the judgment says that it is the complainant counsel is like a junior counsel to the prosecutor because in all state cases, particularly the sessions cases, the prosecution is done by a prosecutor. The complainant counsel can go and assist in drafting the written submissions, giving him the points, but ultimately the mouthpiece would be the prosecutor. You can't do much. 301 is restricted to only the victim's lawyer. Victim's definition has been amended in 2009, Section 2WA. Victim has been defined. And along with that, when victim was brought in CRPC, then Section 372 CRPC was amended. A proviso was added that even victim can file an appeal. Similarly, Section 24(8) of CRPC was also amended, and the victim was given a right to engage his own lawyer. So 301, victim's lawyer has a limited role to play, but has a very important role to play, provided he plays within the framework of law. Sometimes they want to exceed the jurisdiction and try to bypass the prosecutor. They have a fight with the prosecutor, which actually creates a problem for them in the trial. So there are various judgments. I think I don't have my compilation here with me, but there are many judgments on 301 recently, which we used, and we argued in one of the courts. Since it's an ongoing case, so I don't want to disclose the name. And then Mr. Jay Kishan Sharma, going step by step, senior police official by going to magistrate 3 by filing a contempt as per direction of Lalita Kumari. Yes, you're right, my friend. Mr. Jay Kishan Sharma is right. The third option is because Lalita Kumari, the penultimate paragraph gives the guidelines, and one of the guideline is if the police officer does not perform his duty, then they can be penalized. The departmental action can be taken against them. It's a mandate for the police. So therefore, very often we file contempt petitions in the court. Sometimes they are entertained, sometimes they are not. Sometimes merely by showing notice, your job is done. The police is scared that action will be taken against them, so they register the FIR. Okay, Mr. Rishabh Kumar. In the light of controversies surrounding the transfer of Justice Rakesh Kumar, highlighting the extension of white-collar criminality in lower judiciary. I don't know much about this transfer, so I don't think I'll be able to comment on this because I have not followed this case, unfortunately. This is which High Court, Anubhav?
Is Patna High Court, sir.
Patna High Court. I'm
He's from
sorry, I don't
Patna.
know the facts, so it's not appropriate for me to comment since I don't know the details. And then Manas Sharma says, please discuss the difference between murder and culpable homicide in
It is
short.
uh,
This is, sometimes
out
to
of the scope of
understand
this.
that, yeah, out of the score 299, 300, when you actually read, you need hours to understand. But of course, the basic, I hope Manas Sharma means what he says is culpable homicide not amounting to murder. So that's the distinction between murder and where there's an intention to kill, and then the culpable homicide not amounting, where you have the knowledge that an act may result into death of an individual. These are very delicate. Very, you can actually pick up this topic sometime, because this is something
Definitely.
which you take years to understand the distinction between murder and culpable homicide. And then Mr. Archit Sehgal says, what are your views on the increasing rate of wrongful convictions in India, considering that India doesn't have any specific compensation mechanism on it? Wrongful convictions, I agree with you. Apart from the compensation, my biggest worry is the aspect of bail. Anubhav, what we see every day in the court is that the judges are very reluctant to grant bail in heinous offenses. Rightly so. There is an inherent reluctance. Very heinous crime. Why should he be granted bail? Although every 5-6 years we have one very powerful landmark judgment on bail. We have Dataram, which is pronounced by Justice Madan Lokur recently. He has highlighted the philosophy and the jurisprudence of bail. Then we had in 2G case, Sanjay Chandra's case. Then we have Gurbakh Singh
Sidram
CBI.
Singh past years.
So every 7-8 years we have some very significant judgment, but it hardly makes a difference. So my only question is that bail is a matter of right to everyone, and jail is an exception, which is a very 1977 Justice Krishna Iyer's view. What happens is when during the trial for 5 years, 6 years, you don't get bail, a person is in jail, then he's convicted, then his appeal goes to the High Court. High Court after 4 years acquits him. So 5 years of trial, 4 years of High Court appeal. After 9 years, the man goes out of jail because he's got an honorable acquittal. There I have a problem. Look, trial courts do commit mistakes, which is rectified by the High Court. High Court commit mistake, rectified by Supreme Court. Sometimes you get acquittal only in Supreme Court after 20 years. Recently, I think during lockdown, we got a judgment from someone in NDPS case from the Supreme Court, where in the High Court, sorry, division bench of our High Court, where a man, single bench, I think, NDPS, 20 years of custody, 19 years and 8 months undergone, and man is acquitted. Imagine the consequence that he was never granted bail in the trial court, never in the High Court. Ultimately, he's acquitted. So my friend rightly talks about compensation. I'm talking about who will give him back those 9 years. If he was granted bail and then convicted, things are different. So my personal view as a criminal lawyer is that the laws of bail should be more liberal, irrespective of the offense. And yes, if he's convicted, then suspension of sentence law can be a bit strict, but not bail during the course of trial. Okay, what else? Anubhav, do you want me to take some other question?
Yes, sir. There are a few questions otherwise also coming up. Like, are there questions of data theft, like the online
Yes,
platforms which are being used these days? So, your take on that. There are questions otherwise coming to me also. Data theft. The students want to know
data
about data
theft
theft.
is yeah,
We do
data
not
theft
have
is
the
considered.
protection for data
Yes,
theft.
yes. The future dispute is going to be purely on data because data is the information which we have. That is why you will see that all of the world, in fact, I know India has not made any statute, but US has got a statute on data protection. Their law is that whatever data is protected or stored in US cannot be given to anybody in the world. Their own law says that US can take data from anywhere in the world. If some data is stored in India, they can move an application request through proper channel and say we want this data. But when we want it, they said sorry, our act says we can't give it to you. So therefore, data is the most important thing of the future. We need to have a specific law for it. Now our data, like there's a problem with every app which is created. Now we are talking about this act. What do you call it? Arogya Setu. So sometimes we talk about Arogya Setu. Somebody talk about other that the moment, and then we talk about Aadhaar card. We are giving our information to them. So basically, problem is that when we log into an app, suppose it's an American app, you download it, they ask you to say yes on all the rules and regulations without reading. Mr. Anubhav Kumar, without reading, we on a click, we said yes. We give all our data to American authorities, we give all our data to Chinese authority. When it comes to India, then we start talking about our right to privacy. So idea is that these are basic informations. Of course, sometimes those basic informations are relevant, are important. So you, if you are talking about normal data theft, it's a different question, which is dealt with in the Information Technology Act. If your data which is lying with the service provider or with somebody and somebody has given it to a third party, of course it will be sharing that vital information. But larger issue is where the data is being stored and where the data is being shared with someone else. But data theft is considered in the Information Technology Act is a criminal offense. If it is stolen and shared with someone, then the victim can file a criminal case and also can file a civil case for damages against him.
I think, sir, one or two more questions.
Yeah, we can take
Can
question of Vikas Nain. Mr. Vikas Nain says, can anyone register the FIR against the investigating or filing a false case? Yes, we can. Uh, First is a false case which is filed by a victim or a complainant who says that he's a victim. For giving a false information, he can be prosecuted under Section 182 of the IPC. And the look, the job of an investigating officer is to find unvarnished truth. He has to be independent, just like a prosecutor. Why the state has been given the power to investigate these heinous offenses is because state is not an aggrieved party. State is independent party. So state can conduct independent investigation. If they find the complaint to be false, they can close the case. If there is substance in the complaint, they can file a charge sheet. So investigating officer actually is doing uh, a sacrosanct, a statutory job under the act, which he has to do it independently. Now, if you see the new acts which are now, which are being framed, recently I did a matter in the High Court where the learned judge directed the Commissioner of Police to register the FIR against the investigating officer for not conducting proper investigation. I think it was in the SCST Act. So investigating officer, suppose he fabricates an evidence, then you can prosecute him. But your question is, can register again for filing a false FIR. So if IO files a false FIR, then he can be prosecuted. But if he's investigating a false FIR, then he's doing his job. Then he's doing his job. He can't be prosecuted. He's talking about somebody's talking about
Bar
what else
Council of
do you have?
India rules. The
Anything
BCA
else you
rules
want?
47 to 52. I think one of the questions by Shivam
Yes.
is regarding the BCI rules. Restrictions, sir, which are there that a person cannot practice and at the same time simultaneously perform any other job. So,
Of course, of course. So
yeah.
you have to follow that. You can't have a certificate of practice from the bar council and then you do something else. So if you have to do something else, you have to surrender your certificate of practice. I don't
Vishnu
know if
Shri,
Judges Rekha Monurka. I don't know what judgment is this.
Vishnu Shri Modi has a question for you, sir.
Yes. Okay, I'll read it. Vishneshwari Modi says, "Good evening, sir. What is your say on social media? Media being very active, like things get hyped on media easily. Does it or outrage of it somewhere affect the case or its judgment?" Of course, very, very important question. I've been always saying that there should not be trial by media because earlier it's only media who was picking up the evidence from the case and start discussing on the television. You know, we have television show 8 o'clock, 9 o'clock show where you start talking about the criminal case which is pending investigation. Sometimes it is pending trial, and I don't know. Nobody checks these television channels. They pick up 10 evidence which has been supposedly collected. You know, investigation is always confidential. Investigating officer doesn't share his case diaries with anyone, sometimes not even with the court. Court has to ask for it. Accused has got no right. But you see these television channels picking up bit by bit all the evidence which is supposedly collected. We don't know whether he has collected or not, and start discussing. Discussing means you mention one evidence and bring four people to have a discussion on that. I have very serious objection in this. This is an interference in the justice system. This is a direct interference in the administration of justice. It should not be permitted because you have absolutely no right to discuss the evidence openly on the television, particularly when the investigation is pending and it is confidential in nature. But somebody has to challenge it. The when the trial is pending, the documents of the criminal trial, in my view, are again confidential, can only be with the court, with the prosecutor, with the victim, and with the accused counsel. But it is circulated. Before it is filed in the court, it is circulated, and you find that a document is available on internet. Before the matter is argued in the court, the petition is on the internet, and you start generating public opinion. In my view, this is totally illegal. It should not be permitted. It is inappropriate. It affects the right of fair investigation, fair trial to an accused. The media, the social media particularly, should not be permitted to speak anything about something which is pending. Yes, you can discuss the court orders. Yes, you can discuss the legal propositions, but you can't discuss the evidence and facts. So I think Vishnu Shri has asked a very important question that it has an impact. And sometimes, we all are human beings. It may have an impact on the judges too. We don't know. It can have. So therefore, it should be stopped. If we see these American serials, whenever there is a jury trial which happens, they make sure that if the trial is happening for 3 or 4 days, the jury is not permitted to even read the newspapers. They are not permitted to see to watch television during that period because they get influenced by the public opinion. Same is here. So we should have rules in place with regard to
Indeed,
trial. Yeah,
indeed,
and
the influence is for at this stage of the sentencing also, sir. The sentencing, like for death penalty or life imprisonment, so that decision
yeah,
also often get influenced by the media reports.
absolutely, it does get influenced. There's no doubt about that fact. All these PILs which are filed, all these stories which are done, they have a impact on the mind of the judge and the lawyers too. Everybody gets affected. So I think in cases which are pending investigation, particularly heinous offenses, and cases where the trials are happening, there should be some kind of a rule to at least restrain the media from analyzing. I have no objection in reporting. I have objection in analyzing the evidence and giving a verdict on that evidence. I think it is extremely inappropriate, and it is doing great injustice to the entire justice system. So they should not be permitted to do this.
True, sir. The fine balance has to be drawn between the freedom of
Absolutely.
press and the protection
Yes.
which is available to the prosecution. So we can, if you wish, sir, we can take one or two more questions and then we can wind up.
Yeah. Okay. Please tell me which one is left.
I think
Anticipatory
Piyush
bail.
is asking about the anticipatory bail under SCSC Act. Prithviraj Chauhan's judgment.
Okay. I think anticipatory bail. There was a conflict. I've not done an SCST case recently, but there was a judgment given by a bench of the Honorable Supreme Court with regard to SCST Act, where they said that there was that anticipatory bail should be permitted, inquiry should be permitted, arrest should not be automatic. There is there's a recent judgment of the Supreme Court on that, and then I think there was a review petition which was filed. I'll have to check up. But anticipatory bails earlier were prohibited, but with this judgment, I think a window was opened, and yes, the anticipatory bail was permitted. But normally, what happens is, in case the essential ingredients of Section 3 110, I think, if are not present in a particular case, then you can always file. You can always challenge that case in the High Court, and then also we get protection, interim protection on arrest. So that's my answer to SCST Act.
I think Guru Baksh Singh CBR's case, sir, because it's a constitutional bench case, still holds good on this point on
Yeah, of course.
anticipatory bail.
Gurbak's,
CBR
yes,
case
yes.
is holds good.
No, but there are some statutes which prohibit anticipatory bail, just like
Right.
Unlawful Activities Act, which
NDPS,
prohibits
perhaps
anticipatory.
NDPS, or there are few.
No, no, NDPS, there is no prohibition on anticipatory bail. But in UAPA, there is one. And I think even in SCST, I'm not sure about it. But UAPA, there is a prohibition. You can't ask for anticipatory bail. There can only be regular bail. So that's why probably Piyush is only talking about SCST Act, not general laws on anticipatory bail.
Right. So I think we are about to the closer or the
Yes.
conclusion of this webinar. So
But
it
I
was
have to
a
make one observation. No, I have to make an observation. You said that we are talking about career prospects in criminal litigation, but the kind of questions we got, that all these viewers are already in criminal litigation. That's why
sir,
they're
it's
asking
all
such
because of
important
your
questions.
presence, sir, because students can't stop asking questions from you. So it's all because of you that we have so many questions. And I think
Yes, yes.
it added to the whole webinar because indeed we had the scope of the prospects in the criminal litigation and white collar crimes, but we had different questions. And sir, you have wonderfully dealt with every question. I think many of the doubts must be cleared by now. So,
Thank you.
just to give a summary of the things which we have discussed in this webinar, you have enlightened us with the overall prospects of a criminal lawyer and how it is different from a civil lawyer, and how the importance of a lawyer is there at the very inception, at the stage of investigation. And you also highlighted the qualifications which are very important, or qualities which are important for a criminal lawyer, like you have to be read 24 cross 7, you have to have a knowledge of forensic science, you have to be always ready and hardworking, and most importantly you highlighted the importance of sticking to the norms and ethics which are important for every lawyer,
Absolutely. Very
particularly if
important.
you're
Very
a lawyer.
important. Yes.
And you definitely have answered all the questions and given us very important cases which definitely the students will go back and read in detail. So it was quite enlightening and motivating. I think after hearing you, sir, most of almost all the students would be ready to practice criminal. So it was great uh, to have your experience also and the words of motivation from you, sir. And it was pleasure having you as the guest for today's webinar. I, on behalf of Internship Committee and the entire National University of Study and Research in Law, Ranchi, thank you for your participation in this webinar. I thank all the participants, all the students, all the budding lawyers to be a part of this webinar. So
Thank you so
thank you
much.
so much.
I really enjoyed it. Thank you.
Thank you, sir. Thanks a lot. Thank you.
Thank you.
Thank you all.